Good evening, everyone. My name is Steve Engel, and I'm professor of politics here at Bates. And it's my great privilege tonight to welcome Professor Jeff Tulis to Bates, or I should say welcome back, because Professor Tulis is a graduate of Bates. Professor Tulis is currently professor of government at the University of Texas at Austin. His research and teaching bridges across political theory, US politics, constitutional law and theory, and political philosophy, as well as the US presidency. He is the author of a great number of extraordinarily highly regarded books and foundational texts in political science, including The Rhetorical Presidency, The Presidency and the Constitutional Order, The Limits of Constitutional Democracy, and his latest co-authored with Professor Nicole Mello of Williams College, The Legacies of Losing in American Politics. He holds his PhD from the University of Chicago, and he's taught and/or held fellowships at Harvard Law School, Princeton University, and Notre Dame, among others. Tonight, to mark Bates's observation of Constitution Day, which is actually tomorrow, and to kick off the 2020 election series calendar, Professor Tulis is going to be talking to us about a particular take on the US Constitution and why we view it differently and our relationship to that document differently today than we have in the past. It's an idea he refers to as the Civic Constitution. So before I turn the floor over to Professor Tulis, I just want to express my thanks to various resources and colleagues here at Bates who've made tonight's talk and conversation possible. First, tonight's event is funded through the Learning Associates program, and so sincere thank you to the Dean of Faculty's office. Second, tonight's event and all of the events in the election series this fall are co-sponsored by the Department of Politics, the Department of Rhetoric, Film and Screen Studies, the Office of Intercultural Education, the Harvard Center for Community Partnerships, the Office of Campus Life, and the Dean of Students. So I want to thank so much my colleagues from each of these areas for their ongoing support in making events like tonight's possible. And finally, I want to say thank you to the amazing folks at Bates Communications for helping us navigate all of the technology of tonight's Zoom webinar and for assisting us with advertising this event as well as other events in the election series. A few notes on the technology that we're using tonight. Just so you know, it's acting a little bit odd. Everyone is seemingly signed in as me, Stephen Engel, which is strange. I've never seen that happen before. So I want to make sure that for the purposes of hearing tonight's address, we want you to put yourself on mute. You can keep your camera on or off, but definitely mute it so that we can hear Professor Tulis. Another thing I want to mention is that tonight's event is closed captioned. So if you want to see the captions, all you need to do is scroll to the bottom bar where you see things like mute, stop video, participants, etc., and you'll see a tab for closed captioning. Just click on that and you can click on show subtitle, and subtitles will pop up through the use of AI. Another thing to note is that Professor Tulis will speak for a little under 40 minutes, and then the floor will open for questions. Now, if you have questions, if questions come up throughout and you don't want to lose track of your question, feel free to enter it into the Q&A box, so you can type that in, and we will get to the questions at the end of the talk. If you see a question that's similar to the one you plan to ask, or you think it's a really good question and you want to make sure it's answered, you can also upvote that question, and that will bring it higher in the queue. And I think with that, we will turn the floor over to Professor Tulis. I just want to remind Professor Tulis, currently, Jeff, you're unmuted, so you are good to go. Thanks so much.
I just did that. And thank you, Stephen, for inviting me to do this. I'm thrilled to do it. It's an honor to do this Constitution Day lecture for Bates and anybody else watching from Bowdoin or Colby. And I'm also told that this is, the recording of this is going to be shared with the Alumni Weekend back to Bates in a couple of weeks. And I wanted to begin by just telling my fellow alumni how proud I am of you, of the students of Bates College today, who are doing such a remarkable job under extraordinarily difficult circumstances. I just this morning or just this afternoon checked your COVID dashboard, and it really is an extraordinary achievement to have people back to campus and keeping each other healthy. And that speaks to what a really healthy civic culture really would look like, which obviously Bates has today. So congratulations to you. I really hope we can keep the momentum of extraordinary success that you've achieved so far in building a real community. So let me just begin by starting with a little bit of a bio of a man named Robert Carlisle Byrd, who was from West Virginia. He was the longest serving United States Senator in American history. Senator Byrd became the leader of the Democratic Party, and he held the office of President pro tempore of that body of the Senate for 4 times in his career, making him third in line for succession to the presidency. He died in 2010 while still serving in the Senate at the age of 92. Very few Americans in the past century cared more about or were as shaped by the Constitution of the United States as this senator. This is really actually rather remarkable, because as a young man in his 20s, a little older than you folks, or most of you folks, Byrd established and led a chapter of the Ku Klux Klan, a biographical fact that he regretted and for which he apologized countless times over the later course of his life. The path of his career was not at every moment enlightened. There were more regrets and apologies for some of his votes on issues of race and civil rights, but he eventually became a champion of civil rights, so much so that in 2003 he received the NAACP highest rating and was mourned by that organization at his death. Byrd's views on race and civil rights were shaped by events in his life, in politics, and in his changing ambitions, not by the Constitution directly, but Byrd understood his politics over time as better conforming to the nation's constitutional vision as he matured. He came to see these deeper understandings by virtue of his position, by virtue of his job. Byrd sought to do his job well, and for that he turned to the Constitution as the framers of it had hoped would happen. One of the reasons Byrd became a successful leader of the Senate is because he stood up for the Senate in its contest with the House, and still more in its contest with the President. He stood up for the Senate when other institutions encroached on the Senate's powers and duties, even when the president of his own party, someone say like Bill Clinton, was advancing a policy that he and the party favored. Even when a president of his own party was advancing his policy. So note again, he would insist that the Senate as an institution be respected and be allowed to do its job as the Constitution designed, although that might mean slowing or potentially defeating his own party's policy project. It is a mark of the distance of that the United States has descended from constitutional governance that we now live in a polity in which partisans are willing to openly and shamelessly disparage the oaths of fidelity that the Constitution requires them to take, if doing so will advance their partisan position, such as, for example, refusing to hear from relevant witnesses in an impeachment trial of a president. Now, Byrd carried a pocket copy of the Constitution with him all the time in the breast pocket of his sport jacket or suit. He would pull it out and read sections to fellow senators and fellow citizens to buttress some point or to remind them of their duties. The reaction of his colleagues was bemusement. Byrd was seen as an odd duck in the Senate, notwithstanding his power and position. He seemed like an anachronism, a throwback to a prior century. That's because he was. He was that. In the 19th century, there was nothing at all odd about a senator talking to his colleagues about the Constitution. They did not need to carry copies of the Constitution in their pockets to talk about it because they knew its contents well. Byrd himself did not need a copy to aid his own memory. He carried his copy because few Americans, indeed very few senators, actually know what the Constitution says, and still fewer can articulate what it means. To help rectify this situation, Senator Byrd successfully attached a rider to an appropriation bill in 2005 that established Constitution Day, tomorrow, to encourage civic and educational institutions like Bates College throughout the United States as a condition of receiving any federal money to organize events every year to discuss the Constitution on or around September 17th, which was the day in 1787 that the final draft was signed by the delegates to the Philadelphia Drafting Convention. So we're here together tonight because of Senator Byrd. I should mention that citizens were also more constitutionally literate in the past centuries, even though they were less literate in the ordinary senses of being able to read and write than are citizens today. Those of you who have read or read about the Lincoln-Douglas debates know they are among the most sophisticated arguments about the Constitution in our history. Those debates were long and the audiences were large, and they listened to them with rapt attention, interjected comments, and conversed about them afterwards. How did it come to pass that most Americans, including most congressmen and senators and others who work in government, know so little about the Constitution today? Let me suggest two big reasons. First, over time, Americans have come to think of the Constitution as the apex of a legal system that requires a special education, a legal education, to understand it. For most Americans, the Constitution means what the Supreme Court says it means, or what litigants before the court argue that it means. Few citizens are equipped to follow the technical debates that surround most constitutional controversies in the courts. This aspect of our political culture could be called the juridical constitution. It is a vital aspect of our political life and of the Constitution itself, which after all presents itself, the Constitution does, as the supreme law of the land. Who better to understand the law than specially trained lawyers? Increasingly, citizens, legislators, and presidents turn to the court for answers to questions about constitutional meaning. Because the courts and the legal system are established by the Constitution, they are only a part of it, a big part to be sure, but only a part. All of the rest of the Constitution, the design of our entire polity, including the judiciary, is what I'm calling here for tonight the Civic Constitution, to distinguish it from the usual juridical understanding, the understanding that I just alluded to. Because I need to label this neglected one, the civic one, as the Civic Constitution, it sounds like a remnant or residue, something left over of the Constitution when we look outside of the courts to talk about it. And so I want to stress, it's really important to note that the Civic Constitution that needs to be revived and remembered today is actually what was originally understood as the Constitution, the whole thing. Shortly, I will describe in more detail the difference between the juridical and civic constitution. Part of the reason we've lost sight of the Constitution as citizens is that the juridical dimension has swallowed up the rest of the Constitution in the dominant understanding of our political culture. A part has swallowed up the whole. A second reason citizens and office holders generally have a poor understanding of the Constitution is paradoxically wedded to their admiration of it. Americans still revere the Constitution even though they don't understand it and cannot discuss it intelligently. They, by the way, revere the Constitution even if they despise their government or distrust their government or have little faith in Congress or the presidency or both. This is not an accident, but partly a result of the Constitution itself. When the Constitution was proposed, Thomas Jefferson objected that it provided no continuing mechanism for easy revision by the people. Jefferson thought that popular evaluation of the Constitution and potential revision of it should be built into the political project so that at regular intervals, the Constitution would be rethought and revised or re-ratified. Jefferson also thought that people should arbitrate disputes between the Congress and the President over the Constitution. Madison opposed Jefferson on these points strenuously and explained why in Federalist number 49. He thought that regular appeals to the people to reconsider the merit of the design or to decide its meaning would deprive the project of the veneration he thought it needed to succeed. Madison thought, and this is him, quote, "It may be considered as an objection inherent in the principle that as every appeal to the people would carry some implication of defect in the government, frequent appeals would in great measure deprive the government of that veneration which time bestows on everything, and without which perhaps the wisest and freest governments would not possess the requisite stability." Madison prevailed, and the result was a constitution that contains a provision for amendment, but an intentionally difficult process. Now, Madison may have had a very good argument at the time of the Constitution's ratification. We hear echoes of Madison today when some call for a new constitutional convention, which is one of several ways we can amend the Constitution if a movement could meet the demanding hurdle of persuading 2/3 of our state legislatures to call for such a convention. A commonly expressed fear is that such a move might produce a runaway convention that did not improve the Constitution or amend it, but instead replaced it with something worse. Madison may have been right that during his own time, any subsequent convention would have likely resulted in a product much worse than the Constitution that we have. But Madison's preference for veneration through habituation, that is, through living under the Constitution, but not collectively reconsidering it as a matter of course, succeeded so well that it has rendered each subsequent generation less capable of constitutional reasoning, constitutional thinking. Jefferson may have the better argument now that the American understanding of the Constitution and of the polity it brought into being could be improved if citizens were asked to assess the Constitution, to think about it, to rethink it, and to consider alternatives to it. Precisely because the Constitution is so venerated now, even though, as I said earlier, Americans have lost faith in government, it's difficult to amend it. And one should have much less fear that there would be a runaway convention today, that one would be sanctioned, or if a convention was sanctioned and proposed radical change, that it could command the support of 3/4 of the states as required by our amendment process. The bottom line is that asking citizens to rethink their Constitution today is not dangerous and is an excellent way to rediscover its meaning. And conversely, if one understands Constitution Day events like this one as an effort to mainly venerate the Constitution and its founder and the founders, we hurt the constitutional project more than help it. Fortunately, colleges like Bates and universities are in the thinking enterprise, not the veneration industry. Ironically, James Madison was right to worry about too frequent recourse to the people when the people and their leadership were constitutionally literate, while Jefferson might be right that one vital way to educate a constitutionally illiterate people and leadership class today is to publicly rethink the Constitution, to engage more robustly in constitutional conversation. What would it mean to recover the civic Constitution today? So I'm going to begin with a sketch of some of the main features of the Juridical Constitution as an introduction to its contrasting and more capacious alternative. So I'm going to begin with more of a description of the constitutional understanding that dominates our political culture today and sort of pushes us away from the civic engagement in the civic Constitution. Some have argued that the Constitution means whatever the Supreme Court says it means. We know this cannot be true because the court sometimes reverses its previous decision on important constitutional questions. So the meaning of the Constitution stands apart from the will of its interpreters who seek to discern it. Nevertheless, it is definitely true that constitutional law at any given moment is what the judiciary determines it to be. This means that there may be some distance between the best understanding of the Constitution and the judicial understanding, not just because judges might be mistaken or make mistakes, but more because of the purposeful constraints that shape the work of judges in the judiciary. Unlike legislatures and executives, courts do not decide what problems to solve or policies to pursue. Problems are solved and decisions that they take do have policy implications, but these are both the result of their task to decide cases and controversies brought to them by litigating parties. Sometimes, to resolve these cases, they are asked to review the constitutionality of some law. Although the Constitution does not explicitly mention the power of courts to do this, the power of judicial review, classic defenses of this in the Federalists and the landmark Marshall opinion in Marbury versus Madison explain that the power follows ineluctably from the job, from doing the job of a judge or justice. If the judiciary's essential function is to interpret the law, and if the Constitution is the highest law, it follows that ordinary law that conflicts with the higher law should be struck down. But note that constitutional review, even landmark decisions that alter the course of American politics, are always the byproduct of a complicated legal process designed principally to resolve cases and controversies. Courts do not directly address matters of constitutional interpretation. For example, courts do not give advisory opinions on what the Constitution means. The president or the Congress can't just go and ask the judges what their opinion is on some constitutional matter. It has to come through a case. To be sure, the Supreme Court decides to consider very few of the many petitions it receives, many cases that are brought to it. And thus it seeks out and chooses cases that raise what it thinks are important constitutional issues. Still, this process is indirect and filtered through the multiple mechanisms designed by Congress and the courts themselves to establish and maintain a legal system that is fair and devoted to impartially resolving disputes between litigating parties. Before constitutional questions are seriously discussed, parties need to establish that they have standing to bring a lawsuit, that they have suffered a harm that courts can address, that they have brought their suit in the right venue, the correct jurisdiction, that it's the kind of dispute that courts deem justiciable, that is suitable for resolution through courts, that they've exhausted any other remedies, such as administrative remedies, that the law may have provided for their sort of dispute, and so forth. Lawyers have a specialized language and a special education for all of this that I've just mentioned. These matters may be extraordinarily important in a case, but citizens are generally poorly equipped to understand them, and journalists rarely explain them. The juridical constitution is indirect and for most citizens, understandably opaque. One result of this indirection is that courts do not entertain the full range of constitutional disputes and constitutional questions. To take recent and obvious examples, whether a president has abused his power or violated the oath of office is left to the electoral process or to Congress to assess and respond with its own tools up to and including impeachment, trial, and removal from office. In the 19th and for much of the 20th century, most separation of powers disputes, that's disputes between president and Congress, were left to be resolved by the Congress and the president in dialogue and contestation with each other. These aspects of constitutionalism are part of the civic constitution that I will discuss shortly, not the juridical aspect. And it is a mark of the decay of the civic aspect that in recent years, the Congress and the president have appealed to courts to resolve disputes that they had previously worked out between themselves. And the courts have increasingly taken those cases. They've been willing to entertain those lawsuits, giving over the civic to the juridical. A third distinctive feature of the Juridical Constitution is the need for courts to ensure that its decisions are consistent for parties who bring similar disputes. The court does this by explaining its reasoning and solving the legal problems presented to them with doctrines that can guide future courts. Constitutional questions are not revisited afresh with every new case. Instead, courts first try to apply, extend, or modify the existing doctrine that they have created, the existing framework for understanding that particular kind of constitutional matter. Thus, both a commitment to precedent, to not overruling past decisions, and to rationalizing new decisions in light of the reasons given for the earlier ones means that there may be a gap between rendering a stable and just system of constitutional law, which is what the judiciary is trying to do, and the best understanding of the Constitution itself. If an earlier precedent or doctrine is found to be seriously defective, the Supreme Court will abandon its precedent and make new law, as it did in the famous Brown v. Board of Education case, which abandoned the doctrine that racially separate schools could be educationally equal. It's important to note that decisions like Brown that reverse a century of constitutional law are rare, even if there are widely agreed upon mistakes in the reasoning of a long train of cases that shape the doctrine of law. In the study of American political development that Steve and I do and teach about, there's a concept recently popular among people who do this kind of work. And some of you who've taken Steve's course may have heard this concept. It's called path dependency. The notion is that the movement of history is not the product of inevitable historical necessity that rules out human action or human intervention. But when political actors do make choices at crucial moments in history, they set a future path or course for subsequent developments and rule out other paths that once were possible before that crucial decision point. Crucial Supreme Court cases that set in motion a new or distinctive doctrine of law are like that. After the original doctrine is adopted, for example, a particular interpretation of a particular clause of the Constitution, subsequent cases are decided by applying, tweaking, or in some way extending that doctrine rather than inventing a new one, a new path. This means that large portions of the Constitution that might logically be relevant to some matter might be off limits once the court has established a governing doctrine. All of these paths not taken by courts remain open avenues for office holders and citizens to think about, to talk about. They can become launching points for legislation or for criticism of the judiciary, or both. But these paths are not visible to office holders and citizens if they assume the juridical Constitution is the Constitution. A fourth distinctive feature of the juridical Constitution, related to this last point, is that it highlights relatively few clauses of the Constitution and rarely discusses much of the document. Those large number of you that are political science majors, politics majors, government majors, whatever it's called at your institution these days. And one of the things I like about Bates, when I was there, it was government, which is what my department at UT is. They then changed it, I think, to political science. And I think now it is politics, right, Steve? Which is the way it should be. You don't call, if you're a real science, you don't call yourself science. It's just biology or physics. It's politics, it's only political science is because people are nervous that it really isn't what it says it is. So this fourth distinctive feature of the juridical Constitution is that it highlights relatively few clauses of the Constitution and rarely discusses much of the document. And what I started to say was that many politics majors go on to law school. And if one is a law student, you will learn a lot about the Commerce Clause, about the 14th Amendment and parts of the Bill of Rights, but not all the Bill of Rights. You will learn about parts of Article 1 and Article 2, about the President and Congress, but more about such things as the doctrine of separation of powers, even though there is no doctrine of separation of powers in the Constitution. There were, by the way, separation of powers clauses in state constitutions before our federal Constitution. We actually don't have one but the court has found one. You will learn a lot about the Due Process Clause of the 14th Amendment, but nothing about the Republican Guarantee Clause in the text of Article 4 of the original document. You will learn about the Necessary and Proper Clause that speaks to implied powers, not explicitly mentioned in the Constitution, but you will learn nothing about the 9th Amendment that speaks to implied rights that are not listed in the Constitution. One clause of the Constitution you will be familiar with because you learned about it from grade school on, and it's the one part of the Constitution that many citizens do have some awareness of, is the preamble. But as a law student and lawyer, you will learn that the preamble has no legal effect, that it cannot be cited for constitutional warrant the way the rest of the document can. This is a bare outline, indeed a somewhat stylized or oversimplified picture of the judicial mindset. But let me conclude this picture with a final of the juridical perspective, with a final observation that follows from the diminishing significance of the preamble. For the most part, when thinking about the Constitution, courts try to determine what it prohibits government from doing rather than what it requires government to do. This is an oversimplification, but still helpful, I think, to suggest that the thrust of the juridical picture is one that thinks of the Constitution as a charter of negative rights and proscriptions rather than a document that requires government to fulfill or advance positive purposes. So let me turn now to the Civic Constitution as the alternative way to think about things. One, by the way, that includes within it the juridical, but is more capacious. After the Constitution was ratified and citizens began to live under it, they continued to understand it for a century or more from the perspective similar to a framer of it, that is, like one responsible for making and maintaining a whole polity. They understood the Constitution as something more than, though including, a legal system. From this perspective, the civic perspective, the Constitution is more like an architectural design than it is a legal code. To be clear, to think like a framer or a founder is not to search to determine their concrete intentions for each clause or word of the Constitution. It is not an historical project of original intention seeking. Though some Federalists and Anti-Federalists were so insightful that one can certainly be helped by reading them and emulating how they thought. I want to stress how they thought, not necessarily what they thought about a particular clause, institution, or right. We need to think for ourselves, but we have lost the art of constitutional thinking that they exemplify. Interpreting and conversing about a polity as designed is different than talking about it as a set of laws to be enforced. It is a different mindset and requires a different set of skills. To be clear, informed citizens should be able to converse about important court decisions as well. But even those conversations will be better if citizens began from a more capacious point of view. The civic perspective begins with a common sense reading of the whole Constitution and explores how its various parts fit together to depict and generate an actual polity. When citizens debated whether to adopt this Constitution in the first place, they argued about the meaning of specific words and phrases, to be sure, but the bulk of their arguments, the bulk of what they talked about, was about the whole design, what it meant, and what kind of polity would be generated by this design. Would this new regime be capable of avoiding the problems the states could not resolve under the Articles of Confederation? They argued about what kind of polity the commitments represented by the Constitution would bring into being and how they would look in the future. The Constitution as an architectural design was not just a settlement of a political dispute in their own time, but rather an argument over how to reconstitute the polity for the future. That's why, for example, there was a lot of argument about whether the Constitution would create a large, commercial, increasingly urban polity, even though the ones they inhabited were small, rural, and agricultural. The opponents of the Constitution didn't want to give all that up, but they agreed with the proponents of the new plan that this is exactly the kind of future it would bring into being. The idea that the Constitution would set in motion social, economic, cultural, and political change, that it would generate a polity that would change over time, and that its institutions were designed to change as well to meet those foreseeable futures, means that the idea of change was built into the Constitution from the very beginning. This renders a common debate within the juridical perspective, that between so-called originalists and so-called living constitutionalists, or people who speak about a living constitution, their debate is fundamentally mistaken. As a future-oriented design, the meaning of the Constitution cannot be tethered to the extant practices or prejudices of the 18th century, as the originalists might have it. The design set in motion change at its origin. The Constitution contains a political logic induced from the beginning, such that it might be said that what is new later, in a practical sense, is not a living adaptation, but was theoretically there all along. Federalist Paper number 10, which articulates the case for a large commercial republic of continental scope, a dramatic change from the Articles of Confederation and from the earlier ideas of how to create a successful constitutional democracy, is often regarded as the most profound, influential, and important essay ever written defending the Constitution. It does not mention a single clause, but rather highlights the fundamental aspects of this design and their implications for the political development of the polity, set in motion by a commitment to the fundamental features of the Constitution. From a civic perspective, the design commitments of a Constitution go well beyond parsing specific clauses. It speaks to the Constitution's fundamental commitments and how they differed from the previous Articles of Confederation, the philosophic and theoretical basis for those commitments, and the political implications of them. These features, the fundamentality of the Constitution and its commitments, its philosophic or theoretical basis, and its political, cultural, psychological, economic implications, these features define constitutional thinking from a framer's perspective, but they're alien to the juridical mindset. Returning to the most basic or fundamental level, the Constitution is a project to empower and advance purposeful government. As I mentioned, many legalists, especially today, think the Constitution is fundamentally a set of limits on government. The Constitution contains both positive purposes and powers and negative limits or restrictions. The ineluctable starting point is that positive purposes are fundamental and the restrictions or limits on power, though vitally important, are secondary. That's the reverse of the juridical view. If limits were fundamental, the way the juridical thinks, which is the premise of many, as I say, who hold that mindset, that would mean governing is the greatest threat to the common good, and no government would be preferable to some government, no matter how minimal. If government is the fundamental problem, why have government at all? As long as there's a problem for which one moves out of the state of nature into some sort of governing order, positive purposes of some sort are the fundamental starting point. Our first objective becomes to achieve those purposes or to solve that problem. And our secondary concern becomes the worry that power to do that could be abused. If we knew in advance that power inevitably corrupts, would always be abused, and that no problem could be solved, there'd be no reason for any constitution at all. And thus, from a civic perspective, the preamble is and ought to be the most important paragraph of the plan. It sets out the positive purposes of our governing order and the standard by which one should judge the success of this political design. The rest of the plan are the structures and powers designed as means to achieve these ends, to form a more perfect union, to establish justice, to ensure domestic tranquility, to provide for the common defense, to promote the general welfare, and to secure the blessings of liberty to ourselves and our posterity. The civic perspective asks how the means of the Constitution are fitted to these ends and whether they work to advance these ends. if we can no longer say that government is capable of serving the ends of the preamble or of advancing our polity toward better realization of those ends, then it's time to think about a new constitution. That's why it's important today not to venerate the Constitution, but to think about it. The design of the Constitution is an organization of ends and means, with the ends more important than the means. The civic perspective begins from this basic idea, whereas the juridical perspective tends to elevate means over ends. It seeks to ensure that the means prescribed are the ones deployed. Process and forms are vitally important in a constitutional democracy, so the legal aspect is a way to safeguard them. The judiciary is a kind of hall monitor for process. But when the juridical point of view dominates all of constitutional thinking, the polity as a whole comes to think of the Constitution only as a charter of negative liberties or as a safeguard against the abuse of power by government, of the things government should not do rather than the things it is obligated to do. One reason the juridical perspective has this emphasis is there are many ways a polity can seek to perfect itself, and the choice among these are the point of partisan debate and legislative deliberation. Seeking not to supplant the legislature, courts try to confine themselves to the question of whether some action is permissible, yes or no. But from a civic perspective, one could argue not only whether some policy is permissible, whether it is allowed by the Constitution, but also which policy advances constitutional purposes better than another. It was common in the early 19th century for congressmen and senators to argue whether some proposal was more constitutional than another. This is a concept anathema to the juridical point of view. Judges don't and shouldn't decide whether some policy is more constitutional than another. That supplants the legislature. Courts rightly confine themselves to the minimal threshold of permissible. So the juridical constitution asks yes or no with respect to matters of constitutionality. Is it or isn't it constitutional? While the civic perspective may ask about more or less as well as yes or no. It's a further mark of the decay of democratic discourse in our time that legislatures do not even consider the minimal permissibility or constitutionality for themselves, the yes or no question, when they draft legislation today. This is a fairly recent development, the total abdication of constitutional judgment by the legislature. Today, if a question arises when a bill is being debated regarding the potential constitutional problems within a piece of legislation, the Congress includes what's called a severability clause in their bills. These clauses allow the Congress to avoid constitutional questions altogether by throwing the whole matter to the courts and stipulating that if the court finds some aspect of their bill unconstitutional, they can sever it from the rest of the legislation and leave the rest intact. This rarely, if ever, happened in the 19th and early 20th centuries. In the past, Congress developed its own views regarding the constitutionality of legislation that it passed, and those views shaped and informed their deliberation. Because the judiciary is designed to resolve cases and controversies, it seeks definitive and lasting answers to the problems posed. It seeks to settle the issue. The political theorist Mariah Zeisberg, who's at University of Michigan, has labeled what I just said, this attempt to settle cases and controversies. She's labeled it the settlement thesis. The idea that in issues of constitutional contestation, courts seek to settle the issue, not just between the parties, but as a matter of constitutional interpretation for future similar controversies. The reason the judiciary stayed out of disputes between the Congress and the presidency for most of American history is because the political branches contesting claims to constitutional authority regarding, for example, war powers or information, were independently legitimate and not appropriate for settlement. Each institution has viable and important constitutional authorities that were designed on purpose to conflict. These issues were not settled, but rather temporarily resolved by the political branches themselves in argument and contestation with each other, such that the same constitutional question might be resolved differently in differing political circumstances. Zeisberg calls this a relational understanding of constitutional interpretation as opposed to a settlement understanding. To give one example of how this is supposed to work and used to work, consider the issue of executive privilege. That's the claim by a president that they don't have to give up information to the Congress, that they can keep it confidential within the executive branch. There's no explicit clause on this matter in the Constitution, but it is actually a reasonable inference that the executive power that is vested in the president requires confidential advice giving. For law enforcement, so as not to tip off targets of investigation, for national security, and for the advice giving function itself to make it more likely that advisors will feel free to give confidential and controversial advice and not hold back. So if some of you go to work for a president, you may be tasked with doing research on some morally questionable topic, and you may say, I don't want to do it. And the president's going to say, just do it. I need the information. I need the opinion. I need the options. You would be hesitant to do that if you knew that your advice was going to be shared with the world, because you yourself might have some political ambitions. So the advice giving function itself requires confidentiality. And that's why presidents, all presidents, not just Donald Trump or Barack Obama, all presidents care about executive privilege to some degree. But it's also the case that the legislature has legitimate grounds for asking for the information from the executive. The Constitution gives the legislature responsibilities that require information for oversight, accountability, and lawmaking. Their job suggests that they have a right to some of this information. So who should prevail in any given instance? This is a political question, not in the merely partisan sense of which side are you on, but in the larger sense of how important is the information to Congress versus how vital the secrecy is for the executive. The balancing of those questions were routinely and regularly resolved by negotiation in which each side responds to the arguments of the other. For example, if the executive worried about leaks of national security or law enforcement information, a congressional committee might propose limiting the access to the information and making provisions to maintain its confidentiality. In normal administrations, these accommodations are made all the time. In the event that agreement cannot be achieved, each branch has tools at its disposal to either extract or protect the information. And the willingness to use those tools is a rough measure of the importance of the issue in the conspectus of political concerns at that given time. Congress may subpoena witnesses and documents, hold witnesses in contempt, and if the issue is serious enough, censure or impeach an office holder or even the president himself. This is an example of the results of the architectural aspects of the Constitution that are missed by the juridical point of view and are subverted to the extent that one thinks too legalistically. The Civic Constitution envisions a government designed to vindicate different desirable qualities of democratic governance. Democracies require responsibility to public opinion and majority will, but democracies also require competing things like attendance to rights, individual rights, and to the safety and security of the nation and its people. To achieve these sometimes competing concerns and objectives, the Constitution reimagines governmental design to be a complex of structures, powers, and duties, and induced perspectives and dispositions like deliberation, decisiveness, and judgment. Political conflict in this vision is a virtue to be exploited and made fructifying, not a pathology or malady to be overcome. The vision I just described captures well constitutional understanding and practice in the 19th and 20th century, early 20th century, because legislators and presidential advisors were constitutionally literate and had what could be called a constitutional consciousness. This is the Civic Constitution, and it has waned and withered in our time. It is withered not just because legislators no longer have the memory and skills for this kind of argumentation, but also because these contests between president and Congress require a watchful people, a people that can understand enough of the argument to be a factor in the resolution of disputes between the political branches. Yet as striking the contrast between the robust civic constitution of the past and the constitutional decay in our time, it must be conceded that the problem might have been unintentionally induced by the original Constitution itself. It may be the case that constitutional literacy in the past was actually a residue of the education of the generations who formed our polity and who themselves were formed by political regimes that preceded our Constitution, rather than by the success of their architecture. Our problems today may have been latent from the beginning without anybody realizing it for a long time. I conclude with this point because of a remarkable observation by Alexis de Tocqueville in his classic Democracy in America, written after his trip to the United States in the 1830s. Tocqueville remarked, it's one of his more famous observations, that all political questions in the United States seem to eventually turn into legal issues. Tocqueville praised this aspect of our new democracy. It was not yet true what he said, that most political issues at the time he wrote, regarding most political issues at the time he wrote, but it was a tendency that he was able to see and note. Tocqueville was afraid that democracy itself, for all its virtues, was its own worst enemy. The problem for democracy, he feared, was that it would become too democratic, leading to majority tyranny and other pathologies. He thought the solution to this problem was to find some substitute for aristocracy, some democratic institution that could mitigate democracy's worst tendencies. He thought lawyers and judiciaries, and the judiciary did this. They were compatible with democracy because anybody can become a lawyer if you put in the effort. Judges were selected by democratic processes and so forth. But the special training, the focus on process, on forms, and on formalities made them a kind of ersatz aristocracy that could mitigate the worst aspects of democracy. Tocqueville was right that over time, political questions would become legal disputes in the United States, and that lawyers and legalism would loom large in our political culture. In that, he was brilliantly prescient. He was wrong, very wrong, however, that this would prove to be a healthy aspect of democracy. The ersatz aristocracy of lawyers and legalism would truncate our Constitution and diminish our constitutional culture. Civic engagement, also prized and lauded by Tocqueville, would wither, not thrive, partly because of the dominance of the juridical Constitution in the civic life of the United States today. I'm ready for questions.
Great. Well, thank you so much in giving us this really deep insight into different ways to think about the Constitution and into the change over time as to why we think about the Constitution in this more narrow, and I think, as you highlight, deeply problematic, limited juridical format. So I want to remind people that if they have questions, all you need to do is put them in the Q&A box. So just click on the Q&A at the bottom of the screen, and then all you need to do is type your question. So if you have a question, please put it in the box and I will read it out so that Professor Tulis can engage with it. As we're waiting for some questions to come in, I have a question. And hopefully, because people can hear me, I'm just going to say it aloud rather than type it in the box. And that's really a question about, what do you think are the incentives for Congress and the president? Is this the change over time to the elevation of the juridical Constitution? Do you see that as a kind of loss of norms, or do you actually see incentives in place for members of Congress and the president to actually willingly cede authority to the court?
Well, Steve has kindly the answer to your question is tough. And Steve has kindly invited me to actually come back next month to talk about congressional abdication. And so I'm going to spend actually a lot of time talking about the ways in which the Congress has given up a lot of its powers to the president, but also how the Congress has turned to the courts over things that it previously just cared about itself, and how the president and Congress have turned to the courts over issues that it had previously dealt with itself. One thing I can say here is that one of the things that has happened is that people may be surprised that my description of the Civic Constitution suggests a constitution of robust contestation. Because some people might say, today, we have too much contest. We have too much partisan bickering. We have too much gridlock. We have too much partisanship. And they would be right. And so what I want to suggest is that that the Constitution's role for contest has actually been filled by the invention and reinvention of partisanship. When partisanship was originally invented, it was invented to make the Constitution work better. So partisanship assisted the Congress to do its job. And so that, Senator Byrd's a good example. He was a partisan. He was the leader of a party. And he cared about his party. But the party was subsumed into the institution. The party did not actually capture the institution. What we found in recent years is the literal takeover of constitutional institutions by political parties. That's part of the deal of hyperpartisanship. That's part of what Mitch McConnell is all about. For Mitch McConnell, the Republican Party, as he understands it, is clearly more important than the Senate because he's willing to change any of the Senate norms if it will serve his partisan interests. Well, that actually wasn't the case before. So it's a complex story how we got to that, but the descriptive point would be is that we did. And then once we did, it poses this problem. Well, how do you actually then resolve any disputes? And so it becomes more attractive then to say, well, let's let the court decide. And so they're going to the courts more about things that the courts used to themselves previously declined to take. And then once they do that, of course, it creates a further problem, which is it tends to start to delegitimize the court. When the court takes things that are too political, it delegitimizes the court. The two most recent examples, I think, would be it resolving the 2000 election, as it may have to resolve this election, which could have been resolved, by the way, in Congress. It doesn't have to go to the court, according to the Constitution. And the second example would be the voting rights case, in which, I don't know, the voting right, the bill that, the law that kept the Justice Department monitoring voting in some states was repassed overwhelmingly, with 95% of the votes in favor of it in both houses of Congress. But the court decided to weigh in on that and to strike that law down, even though it tends to, defer on other issues to what the legislature thinks. It was clear what the legislature thought. And in fact, it said, well, they were just being politically correct. They didn't really think that. And so we're going to decide, well, that was a huge political intervention that I can't imagine actually having happened just a few decades ago.
So I've learned, thank you for that really comprehensive answer. I think what I've learned from our tech support is that the Q&A function is not working because of it's related to why everyone or the vast majority of people on the call are listed as me. But if you do have a question, the easiest thing you can do is you should be able to unmute yourself and simply talk directly to Professor Tulis.
That'd
So
be
we can
great.
treat this
That'd be
as
great.
regular Zoom.
That's good. There are only 20
webinar.
people, so let's talk.
Yeah. So if you have a question, just go ahead and unmute, and you should be able to ask your question directly.
I have a question.
Sure.
Thank you, Professor, for taking the time to talk to us tonight. So I'm curious, do you think the proper solution to this issue is just to, rewrite a completely new constitution?
Well, maybe, but I would say definitely the proper solution to this is to think about that, to think about whether this constitution is up to the task, and if not, what a new one would look like. That's different than me saying, because the process of thinking about it to me actually is more important than any particular alternative constitution I have in mind. For one thing, it would make us better understand the one that we have, the parts that work, the parts that don't work, and so forth. But there is a lot, as you might, as some of you I'm sure know, there is a lot of concern today about whether, for example, the Electoral College is a good thing, whether the Senate gives too much power in an undemocratic way. This was a worry, by the way, when the Senate was even made from the beginning. And it was the result of a kind of compromise. And there were good reasons for having a second branch of government and having a second smaller branch of government. But the idea of giving every state equal representation was a big compromise. And it was a compromise so at odds with the democratic thrust of the Constitution that when they wrote the amending clause, the clause that says how you can change the Constitution, they said basically if you go through this complicated set of hoops that are required, you can do what you want, but there are two exceptions to that. So that even if you got all the votes, even if you got 3/4 of the states, which you wouldn't be able to probably in this example, you can't change the representation of the Senate. The other example, by the way, is no longer is moot, but it was important at the time, was there were 3 clauses that preserved slavery in the Constitution. And one of them prohibited Congress from banning the importation of slaves for about 15 years. And there was a clause that said you can't do that. They were said you can't do that. The Congress is not allowed to pass a law doing that. And they thought a little bit deeper into it. Well, what if Congress amended that part of the Constitution? So they put that in the amendment clause that you can't amend that, right? Now, why those 2 points are interesting is they're both 2 examples of things that are so at odds with the fundamental feature and aspirations of the Constitution, and aspirations of constitutions, that you had to make special arrangements to protect them, because the Constitution left on its own was going in a more democratic direction. So that's a reminder that the Senate's a problematic institution. And so it was from the beginning. So a lot of people have been thinking, well, maybe we should be thinking about changing things. People have thought about whether there should be limits on the length of terms that Supreme Court justices have. People have been thinking about whether a president should be only denied, limited to 2 terms, or to go back to what we originally had, which was unlimited re-eligibility. So things are bubbling up, conversations that people want to have. And in fact, I don't know if Steve knows this, but there is this summer a kind of academic mock constitutional convention that Sandy Levinson and others have organized. He's a colleague of mine at UT Law School, in which academics and law professors and so forth are just going through the exercise of imagining what a better constitution would look like. Not just amending this one, but what a better one would look like. And so I actually do think that that's a good thing for students to do. And I think that that's more important than to start at the beginning by saying, well, what should the new one look like? Just start thinking about what's wrong with this one and whether it could be amended to be improved or whether you would need a whole new one. That itself is a very, very interesting question. When is amendment enough and when should it be completely new?
Great, thank you. Other questions? Just remember you can unmute yourself and just ask directly.
So at the beginning of your talk, you were just similar to the last question, talking about how if you gave people more of an option, more of an ability to change the Constitution or to hold constitutional conventions, this might increase literacy of the Constitution. I mean, I'm from the state of New York, and we have in our Constitution, a referendum comes up every 10 or 20 years, I forget what it is, to hold a constitutional convention. When I was a senior in high school, that referendum came up and I actually did a little bit of work on it. And I don't think that really has improved people's literacy of the New York State Constitution. So the question is like twofold. How do you think like you get people to discuss this more? And also, do you think that it is even possible to get people to discuss and become more literate?
Yeah, I think that's an excellent point. And I also think you might be right that it's quite possible that it would be a disaster. Getting a bunch of ordinary Americans together and just say, well, what do you think? Because it takes some reflection time, thinking, reading, and so forth. All that's true. What might count in its favor? Well, for the last 15 or 20 years, there have been a series of very, very successful experiments by political scientists on something called deliberative opinion polls. Ordinary opinion polls are when you just go ask what people think and then add it up and present the results. And this deliberative opinion poll idea was, well, suppose we didn't ask people for their off the top of the head ideas. Suppose we did the same thing you do with a public opinion poll, which is get a random sample of people. Does everybody know how public opinion polls work? You know, they get a random sample of the whole population, such that arguably you're getting the opinions of everybody with only 100 or 400 people, because it's a random sample of everybody. So you do the same thing, only have that sample come together for a weekend or a week with experts on some matter of public policy or even constitution making, but public policy is when what most of the experiments are about. To give you one example, in Texas, the state law requires that they consult public opinion before the utility commission makes recommendations and policy with respect to the investments they're going to make in different forms of power, electric, gas, nuclear, all that stuff. And the utility commission was freaked out because, the public, what does the public know? These are very, very complicated questions. But they were by law mandated to consult public opinion. So they said, well, we'll try this deliberative thing. And they brought a random sample of Texans to the University of Texas and did one of these deliberative opinion polls. And the way it works is they take an ordinary poll at the beginning. And then you have the deliberation over the weekend or the week, and you take it at the end. And not only was there tremendous movement and people had changed their minds on all sorts of stuff, but the utility commission said, we can't believe it. What these ordinary citizens randomly chosen came up with turns out to be better than what our experts had proposed, because they actually had thought through more seriously, not just the technical aspects, but what was involved in the political trade-offs and all that sort of thing. Because those are not technical questions, those are political questions. So this has spawned a whole literature. Some have given it a fancy term of democratic epistemology. That somehow if you have a real democracy, it's not just the second best way of getting answers. You might actually get better answers from a properly constructed democratic setting than you would from experts or elites. So that gives me some hope that, that what I'm talking about has a possibility of having that educative function. I mean, one of the problems for the state ones is that state constitutions in some sense are not real constitutions. A colleague at Johns Hopkins named Emily Zakin would disagree with me on this. So don't take my word as gospel, but I don't think they're real constitutions. I think that they are sort of like, they are legal codes, not architectural designs. They are legal codes for their states. They really don't shape the culture, for example, of their states, even though they shape the offices and powers and duties and so forth. And so they're often prolix, like a legal code, and they're changed often and so forth. And so what it means to actually, talk about them and debate about them and so forth is, I think, different than what it would mean to talk about the US Constitution. But to go back to your original point, I don't want to say you're wrong. I just want to say there's a possibility that there might be education here, but you may very well be right.
Other questions? I think we have time for at least one more.
Hi, Professor. So my question is, in responding to Abra's question, it seemed to me like you were saying, like, what's most important is just to get people discussing civics, to get people thinking about it and discussing it. What do you think? I mean, I guess you kind of answered that in Zach's question, but
well, I think they have to be in a setting in which they can think about things with some help. I mean, it has to be done very, very carefully, because help shouldn't be indoctrination. It shouldn't be partisan. It shouldn't be trying somebody. You follow what I'm saying? And that's why they work very, very hard in these deliberative opinion poll settings to try to guard against, generating outcomes by the way the experts they bring in to give their views express themselves. But people are going to need something of a civic education in order to have these conversations. I don't know, did some of you go to high schools that participated in the We the People program? This is a national civic education. And they have these, instead of debate, they have mock hearings that result in a competition where they take one high school from every state to DC, and the judges include Supreme Court justices and so forth. And they give them these sort of constitutional problems to wrestle with. Well, they don't just sit down and talk. They study stuff first, like you do in preparing, for policy debate or something like that, only it's constitutions. And then they converse with each other. So it would be something like that. So you're absolutely right. The idea that you just pull people together and say, hey, talk about this. No, that's not going to work.
Yeah, I mean, my question was going to be, and you kind of anticipated it there and answered it, was like, what's the best way to get people thinking about that? Is the policy like some type of nationwide like civics requirement in high school? Like, should everybody that graduates from Bates have to take Professor Engel's con law class? Like, that would probably be a lot of work for you. But
yeah, I want to stay away from the requirement piece of it. Because I don't know whether requirements sometimes people make things worse than not requiring, but having and caring about civic education as a component of what both a high school and a college education is all about is, I think, vital. We actually have a law in Texas where I teach that keeps my department big, actually, because we have to staff all these courses that we're required to teach by the state constitution on both the Texas government, American government, and the Constitution as well. 2 semesters. Yeah, I would say yes, not the requirement part, but yes, civic education should be something that colleges that design their curriculums and high schools that design their curriculums should be thinking about as is important as many of the other things that they have in their curriculums.
Great. Well, thank you. And thank you everyone for questions. Just the last comment reminded me of an experience I had in grad school. I TA'd constitutional law for Professor Akil Amar, and he was very adamant that constitutional law have no prerequisites, that it was listed as a 200 level politics course, but that anyone should have access to it. And it was taught in the fall semester, and even a first semester, first year should be able to get into it, precisely because he understood that as kind of a civic foundation. So I think engaging with the Constitution is tremendously important. And I think thinking through Professor Tulis's idea of the civic constitution, something that we've lost, and thinking about how to recover it has been a really interesting and useful exercise tonight. So I want to thank everyone for making time to participate. And I specifically want to thank Professor Tulis for sharing his thoughts with us tonight. And I want everybody on the call to know that Professor Tulis will be coming back and giving a second talk as part of the election series on October 21st. And hopefully on that one, we will fix our technical issues and not everyone will be listed as Stephen Engel on the call. But I hope everyone enjoyed the talk tonight. And again, thanks so much to Professor Tulis for—
Thank you for coming. Hi, Andy. Thank you.
Jeff, how are you?
Hey, good to see you.
Steve, thanks for inviting even the Bowdoin people here. It's
Yeah, of
much
course.
appreciated. And I feel smarter having been labeled even as Steve Engel for just an hour. This is good.
Well, thank you again. Well, everyone, I hope you have a good night and hope to see you soon again on the next election series event. Basically, there's one every Wednesday night, so pay attention to your Bates Today in your email and you'll get more information about what comes up next. All right.